Good afternoon, Your Honor.
Good afternoon, Mr. Ghosh.
Good afternoon, Your Honor.
Good afternoon, Mrs. Bijoy.
Good afternoon, everyone. Good afternoon, Your Honor.
Good afternoon, Mr. Bassi. You are far away from me in your boardroom, and there is a considerable echo. Could you speak again, please, just to try the
Good
sound?
afternoon, Your Honor. Can you hear me all right, or is there still an echo?
There's a very bad echo. That is, everybody's agreeing with me. You're going to have to move somewhere or do something.
I'm going to do something better. I'm going to get off the room projector and get on my laptop. That should make things easy. Give me 1 second, please, Your Honor.
Okay.
Your Honor, for the yesterday when we started, we discussed about the closing submissions. So
Yes.
after,
Yes,
so after this, we'll have a short closing submission and then give written submissions, or we continue with the closing.
I'm going to discuss that with you. I am inclined at the moment to consider that written submissions are going to be better, because there is an awful lot of ground to cover, and I would rather have one cohesive set of submissions from both parties rather than something delivered, and no disrespect to you, extempore at the end of the evidence in the case, which I make no bones about it, is difficult. And I think a considered reflection on the evidence and the issues, there's one or two that I will raise with you after we've had this evidence from the accountant, Mr. Bassi, today, so that you can deal with them in your written submissions. I think that is the best way forward, so that we will adjourn for written submissions to be provided. If I take the view that I need to question your written submissions or hear from you further, I will convene a further oral hearing before I make my decisions.
Yes.
So that is the way I think we will proceed after Mr. Bassi's evidence today.
Good afternoon, Your Honor. Can you hear me all right now?
I can hear you perfectly now. Thank you, Mr. Bassi. These are wonderful, wonderful things, these great boardrooms, but they do present technical problems. And there it was immediately apparent to us all here in our various little offices.
As they say, Your Honor, technology works until it doesn't.
It does indeed. Right. So we need to formally reopen the hearing. I'm sorry once again, Alia in the registry. I've started before you have dealt with the formalities. Would you please convene the hearing?
Thank you, Your Honor. Good afternoon, all. This hearing is in the matter of CFI 030-2023 and is being held by way of video conference before Justice Andrew Moran, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al Hijaya Al Nubi, Advocates and Legal Consultant. Lead counsel is Ms. Asha Bijoy. The defendant is represented by Alex Ensemble. Lead counsel is Mr. Santanu Ghosh. Thank you, Your Honor.
Thank you very much indeed. Well, now, Mr. Bassi, I'll just explain the procedure to you before we start. I have received all of the evidence now in the case, apart from your evidence. And the way that is given is in the form of the report that you have prepared or adopted. I suspect a bit of both, certainly the latter for the purposes of giving evidence today. But your report is in evidence before me already in its full form, with all of its appendices. and I have looked at the material parts of the appendices. I myself have some questions to ask of you, and I will let the parties come back on those questions after I have asked them. But the way it works is this: your evidence in chief, as we call it, or direct, as the Americans prefer to say, is all before me in written form. So Miss Bijoy will simply call you, you will be affirmed, and you will attest to the truth of your written evidence. Then you will be cross-examined by Mr. Ghosh, and then you will be re-examined by Mrs. Bijoy. And as I say, I may have some questions as well if they don't ask the questions that I want information on. So I hope that makes it clear to you how we proceed in these matters.
Yes, Your Honor, thank you. That's very clear. And I also wanted to thank everyone for accommodating this afternoon schedule. I had some things that I was not able to move around. So I really appreciate everyone understanding of this.
Well, that's all perfectly understood, Mr. Bassi. I was just concerned in case we were going to lose another day in this case, but that has not happened. So we can proceed now, I hope, as efficiently as possible. Mrs. Bijoy, would you like to call your witness and ask whether he wishes to affirm or take an oath?
Yes, Your Honor. Mr. Bassi, would you be affirming or taking a oath?
I would like to take an affirmation.
Very well.
Thank you.
Alia.
Can you please confirm your name and occupation for the court's record?
Akash Bassi, partner, Grant Thornton, UAE.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your
Thank you
Honor.
very much, Mr. Bassi. Mrs. Bijoy?
Yes, Your Honor. Mr. Bassi, you have submitted an expert report in this case, which you will find on page number 251 of the supplementary bundle. I hope you have access to the bundle.
Yes, I have access to the bundle. I can see it online in front of me. It's page 251.
251, yes. And it goes all the way up to 279. And if you look at the 271, do you confirm to the court that this is the report submitted by you?
Yes, I confirm this is a report submitted by me.
Can you also confirm your full name for the court's record?
My
as
full name,
reported on the expert report, please.
sure. My full name is Akash Bassi, Your Honor.
Thank
you. Could you also confirm that the signature found on page number 279 of the report is your signature?
Your Honor, I can confirm that the signature on page 279 is my signature.
Thank you.
Would you also confirm to the court that the report is true to the best of your knowledge and belief?
Your Honor, I can confirm that the report is true to the best of my knowledge and belief.
Thank you very much, Mr. Bassi.
And just finally on that it represents your true and correct opinion, professional opinion, about the matters on which you have been instructed and asked to give your opinion.
Yes, Your Honor, it reflects my true and correct opinion to the best of my understanding based on the instructions by my client.
Thank you very much. Mr. Ghosh, your cross-examination, yes, please.
Yes, Mr. Bassi, good afternoon.
Good afternoon, Mr. Ghosh.
Mr. Bassi, if you come to page 258 of your report.
The bundle, you mean?
Yes, in the supplementary bundle.
Yes. I have it open.
Yeah, page 258.
I have it open.
So here you have mentioned Al Asil FZD. I believe here it is Al Asil Jewelry LLC, or was it FZD? Or is it a typographical error?
So, Your Honor, as per the information provided to us, it was Al Asil, FCE or LLC. I'm not absolutely sure. It's possible it was LLC and it may have been a typo from our side. But the entity was Al Asil, is what we understand.
Okay. So regarding this Al Asil Jewelry or FZD, did you see any document or agreement between Al Asil and the claimant number one, which is Sam Precious Metals, or the defendant number one, Snyder Prime Limited?
So Your Honor, we were provided with a document that reflected provision of working capital of 100 kilos. That's a document that was provided to us by Sam Precious Metals. We have not seen a specific agreement between Al Asil and Sam Precious Metals.
The document which you are referring to now, what is the name of that document or nomenclature?
It was a receipt provided to us by Sam Precious Metals upon receiving the working capital from Al Asil.
That's
Is it part of?
That was for 4.9 million US dollars.
That is correct,
Okay.
Your Honor.
And were you provided any receipt for $1.041 million USD?
Your Honor, to the best of my recollection, I do not recall having received any receipt for 1.202 million US dollars.
1.04. Could you be a little bit more precise, Mr. Ghosh, please? You're referring to, I'll use a neutral term, funds supplied by Snyder Prime.
Yes.
Which amounted to 1.04.
1711.
Thank you for that. Thank you for putting the precise figure in.
Yes, yes.
What, if anything, have you seen, Mr. Bassi, relating to that infusion of funds?
Your Honor, I don't have USD 1.02 million reflected anywhere in my report. If I could be addressed to what specific paragraph the counsel is referring to, maybe I can then provide an explanation.
It's not 1.02, it's 1.04. The precise figure is US dollars 1,041,711, which is an amount Snyder separately provided as a working capital facility to the company.
Your Honor, I am not aware of that, as that was not part of our scope. Our scope was to essentially look at the shortfall of gold as working capital and accordingly carry out an independent computation of the potential loss or profits. I am not aware, nor have I reviewed any information in relation to any other amounts that may have been received by Sam Precious Metals from any entity, including Snyder Prime.
Thank you very much.
Okay, Mr. Bassi. Are you confirming that because of the postponement of the trial, you simply adopted the previous report and you personally have not looked into any documents which were provided by the claimant?
Your Honor, due to the postponement of the trial, have taken place of the original testifying expert witness, Mr. Hisham Farouk, who's currently out of the country. If we go back and look at the report that was originally submitted, it has my name on it along with Mr. Hisham's name. We are both partners in Grant Thornton, and I was very much involved in preparation of this report as the original testifying expert, Mr. Hisham Farouk. Due to unavailability of Mr. Hisham Farouk, I have taken his place today to provide this testimony, as was said in the application submitted before the court.
Mr. Ghosh, paragraph 1.6 of the original report reads as follows. I have been assisted in the preparation of this report by Akash Bassi, partner of forensics, and certain other members of Grant Thornton's UAE staff working under my supervision, and this is reflected in my reference to we when appropriate. However, I confirm that the opinions expressed are my own. So this is quite common, Mr. Ghosh, that partners in firms work together to produce a report. And sometimes I've had it before, the partner giving evidence is substituted with another because it's a common piece of work. Are you suggesting that there's some deficiency in Mr. Bassi's knowledge and understanding of the facts which are deposed to in the expert evidence which has been filed.
Suggestion is, Your Lordship, because he hasn't seen the contribution of Snyder Prime Limited, and Mr. Basi just confirmed that was beyond the scope of the expert. So I made myself believe that probably he was not aware of all the documents which have been provided to the original expert.
Well,
Yes.
the original expert didn't make any reference to that either.
Yeah. Very well, Your Lordship.
This report focuses on the alleged failure to provide 200 kilograms of working capital in the form of gold or equivalent, as it turns out,
Yes.
and the impact that that has had on the profits of the company.
Yes.
Nobody's disputing that Snyder Prime provided the amount that we've just been talking about, the $1,041,000 odd dollars. That's not an issue in relation to this expert evidence.
Yes, I was just trying to understand if, while computing the loss cost to the claimant number one, whether the contribution from Snyder Prime has been ignored. So anyway, I'll continue with it, Your Lordship.
Yes, carry on.
Mr. Basi, kindly come to page 332. This was the audited financial statements of 2018.
Sorry.
Are you there, Mr. Basi?
Yes, just please give me a second. I'm pulling it up.
Okay, sure.
332, you said?
Yeah, 332.
I was not able to print it out, sorry. So it's on my screen. I'm just scrolling down to 332.
Yeah,
Please bear with me.
Sure, sure.
I'm on 332, Your Honor.
Okay. So there's a heading under serial number 3, convertible loans.
Yes, I can see that.
Yes. So I believe you have got the receipt, as you just mentioned before, for 4,900,000 USD, which is a currency loan from third party, which is mentioned here under convertible loans.
Yes.
And what about the gold loan from third party and currency loan from related party?
So we have not looked at the gold loan from third party or the currency loan from related party. We were provided with a receipt that reflects provision of 100 kilos of gold as working capital from Al Asil.
Okay, so nothing else.
Nothing else. As I've said before, Your Honor, our scope was to essentially look to see the shortfall and the resulting loss of profit on account of availability of working capital. We have relied on audited financial statements and the information contained in audited financial statements. In our limitations, we have very categorically stated that we have not gone and validated any underlying amounts stated within the audited financial statements, as that was not something that was part of our scope.
Thank you. So from what you just said, you mentioned you have not validated any of this, whatever gold loan from third party or any other amounts which are there. So just based on the basis of the receipt, if I am not wrong, whatever has been provided to you, you have computed the loss.
Your Honor, I think the question, I'm not clear with the exact question.
It wasn't very clear. Mr. Ghosh, can you try again?
Yes.
I think you simply want to know whether the expert computed the loss on the basis of what he was provided with. Is that the case?
Yes. Yes.
Well, he's made that absolutely clear in the report and in his previous answer this morning. If you wish to dispute that, then ask your question or make your suggestion in an appropriate manner, please.
Yes. One more question from this. According to you, see, if you see at paragraph 4, it's point number 4, trade payables. So according to you, what's the difference between trade payables and loans?
Your Honor, in my personal opinion and based on my knowledge of accounting, trade payables are payables that any business normally has in relation to their day-to-day running of business and buying and selling of products and services. Convertible loans or loans are what an organization may receive from bank or any other third party in relation to financing and other aspects of their operation. That is my understanding based on accounting of what would be a meaning of a loan or a trade payable. If the question, Your Honor, is specific to the underlying trade payables and loans listed in these audited financial statements and where they come from, like I've said before, we have not individually validated the amounts and the nature and the business purpose of these transactions, as these are included in the audited financial statements.
You're not being asked that, Mr. Bessie. You're just being asked a conceptual difference question, and you've answered that. Thank you very much.
My last question will be, Your Lordship. Assuming a scenario where under serial number 3, the first 2 items, any documents were provided to you, will you, and it is ultimately decided in this proceeding that the gold, whatever 200 kg or 100 kg was provided, will you be able to relook into your report and change the status of your report?
Your Honor, in my report, in the limitations section, more specifically 1.5 and 1.7, I have laid out that I'm an expert witness, not a witness of fact. And in 1.7, I lay out if any further information is produced and brought to my attention after service of this report, I reserve the right to revise my opinions if and as appropriate.
Thank you. No other question, Your Lordship.
No other questions. Well, I have some questions. I think, Mrs. Bejoy, it may be appropriate if I ask my questions first, then you can come back on them in your re-examination, because not very much has been asked in cross-examination. I doubt you would have any re-examination as things presently stand.
Yes, Your Honor, I do not wish to do any re-examination now. Right. I would wait for Your Honor to please finish your set of questions, and if required, I will then have the re-examination then.
Right. Well, thank you for that, Mrs. Bejoy. Mr. Bessie, this actually may be what Mr. Ghosh was trying to get at with this page that we're looking at, 332 in the bundle. But you need some explanation before you can be asked the relevant question. So let me give you the explanation. There is evidence before me, whether I accept it or not, that the defendants did bring working gold capital into the company, SAM. This is factual evidence that you're not aware of, that they did bring working capital of gold or equivalent cash into the company to enable it to make the profits which it is claiming it has lost. Do you see? And the underlying case is that although the defendant, Snyder Prime, did not bring in its own gold and leave it invested in the company for 5 years as per the terms of a memorandum of understanding, what it did was to bring in gold from third parties at a cost, which cost was borne by the claimant company, SAM, that is the financing cost of the gold. And thus the company suffered a loss in paying those financing costs for the gold introduced. And looking at this page 332 of the bundle, the convertible loans, do you still have it there in front of you? That
Yes,
page?
I did.
That figure of 2.050198 is said to represent 50 kilograms of gold. You see the figure there, 49,750. That is said to represent gold brought in as working capital by the defendant company, but at a cost to the defendant company, instead of it being investment gold, as it is alleged the defendant promised to do under the memorandum of understanding. So do you see that case? Do you understand that case that is being advanced before me? In essence, what is being said is that the premise of your report, that 200 kilograms of gold, of 200 kilograms of gold that should have been provided, only 100 kilograms of gold was provided, that is wrong. The evidence before me is to the effect that the full 200 kilograms of gold was deposited in the company throughout the relevant period, the loss period as you've described it, but it was introduced as gold from third parties for varying periods, from varying parties, but the gold was present in the company for its use to make whatever profits it could, subject to a financing cost that it would not have incurred if the defendant had invested 200 kilograms of gold instead of only 100 kilograms of gold. So I say immediately, I have not made any decision on whether that case is true, whether it represents a performance or adequate performance of the contract, the memorandum of understanding, and I have to make that decision. But what Mr. Ghosh was referring to is the possibility that I may accept his client's case that it did invest gold, albeit not in the way that was allegedly promised. It arranged for the investment of gold from third parties. Witness to that fact, it is said, is this item here, gold loan from third party. This is just one of the instances of it allegedly bringing gold into the company. And I think the point that you're being asked is, by Mr. Ghosh, is that if I were to find that gold had been brought into this company by a different means than was envisaged, and so that the company did have 200 kilograms of gold at its disposal during the loss period, where stands your quantification of loss that it has suffered? Is it sustainable, this contention that the company has suffered loss, if in fact it did have the gold, albeit from different sources, in its possession when it was trading during the loss period? Do you understand all of that?
Yes, sir, I do understand and follow what you've just said. My work as an expert was to look at and follow the instructions provided by my client and essentially compute the potential loss of profit Sam Precious Metal encountered when it operated with 100 kilos of gold versus if it would have operated with 200 kilos of gold. And if you see in my report, that's exactly what I've done. And I've computed to the benefit of actually having 2 years where the company did operate with 200 kilos of gold. We looked at the results, as you've seen in my report, we adjusted and we have thereby given a difference. I obviously, as of now, can't speak to whether 200 kilos of gold was available from day one or not, as that was not part of my scope or mandate to comment and opine on.
Yeah, I understand. Well, that's very helpful to me. I have to make these decisions, as you understand. But one of my questions was following on from that. I want to know this. If I find as a fact that gold was introduced to the amount of 200 kilograms and it was there throughout the loss period, coming from different sources at different times, if I was so to find, then do you accept that that would seriously undermine your computation, your approach to the computation of loss, which is based on the profits that the company made in the informative period, as you've described it, and that there must therefore be another explanation for the improved performance of the company during the informative period, rather than the fact that another 100 kilograms of gold was invested in the company during the informative period. That, I think, is what Mr. Ghosh is trying to ascertain.
Your Honor, I think it would probably depend, and this is why I think it would probably depend. Hypothetically speaking to what you've just mentioned, if there was indeed 200 kilos of gold available, I think the one thing that we have seen based on the, sorry, I think somebody's,
yeah, there's somebody talking in the background. Will you please turn off your microphones, anyone who's not involved in this debate?
Thank you.
That seems to be better.
Thank you. Your Honor, based on what we looked at, which is the...
It's there again. Perhaps Mrs. Bijoy, you turn off, Mr. Ghosh, you turn off your microphone and I will turn off mine.
Your Honor, you're on mute. I'm sorry.
Sorry, I'm on mute. Everybody else, microphones off. Thank you for telling me. Well, I don't think it's coming from me, so I'll keep my microphone on. And you can raise a hand, Mrs. Bijoy and Mr. Ghosh, if you wish to interrupt for any good reason. So I'm sorry, would you start again with your answer, please, Mr. Bessie?
Sure, Your Honor, thanks. Your Honor, obviously, I want to caveat that I can't speculate to anything without looking at the underlying financial information and the contemporaneous records. But if there was 200 kilos of gold available as working capital, and if we look at the computation that we have done, which is based on 100 kilos of working capital deployed during the actual claim period, the informative period having 200 kilos of working capital. And if you actually look at, in fact, the audited financial statements of 2021 and 2022, they actually talk about the actual gold or equivalent of gold deployed in the notes. And if you compare the amounts to 2020 and 2021, it's almost double in 21. And in 22, it almost remains the same, which clearly indicates that whatever was the amount of gold available in 21 and 22 to Sam Precious Metals as working capital was definitely more than what was available in 2020 and 2019. And therefore, the results are indicative of that. We have also explained, how the organization operates and utilizes gold as a working capital. We have also seen Sam Precious Metals being in a position to take on large contracts because it has access to more gold as working capital. Now, what specific kilos of gold was available back during the actual claim period versus the informative period? Based on what we know, it's 100 versus 200. What I obviously can't comment on what was the actual gold back available back then, to the point of what you're just making right now, Your Honor.
That's very helpful. Thank you very much. Let me just check if I've got anything else. That I need to ask you. I do have some other questions, but they're completely unrelated to this issue. So what I'm going to do, while it's fresh in everybody's mind, I'm going to give counsel an opportunity to come back on my question that I've just asked you, which I think is what Mr. Ghosh was trying to put to you. I'll let them come back on that issue, then I will ask any other questions I may have. So, Mr. Ghosh, can I ask you first of all, did I explore the issue that you were seeking to explore properly with the expert from your client's point of view?
Yes, Your Honor. Yes.
And is that really, were my questions the questions that you were trying to ask before I intervened?
Yes, Your Honor.
Thank you for that, Mr. Ghosh. Do you have any further questions in response, in light of the questions I asked effectively on your client's behalf and the answer that you've just heard from Mr. Bassi? Do you have anything you want to come back on?
Yes, one point which Mr. Bassi just explained. If I'm not wrong, Mr. Bassi, you just explained that in the first 2 years, gold was more than the years 2020 or 2021, or did I hear you wrong?
No, so Your Honor, what I said was, and which is in the report as well, if you look at the availability of gold as was explained and provided to us, it was 100 kilos from 2018, 1st of September up until 31st of December 2020, and then effective 21 and 22, it was 200 kilos, and this is based on what we understand. Now, if you also look at the audited financial statements of Sam Precious Metals for 2021 and 2022, and if you look at the notes to accounts, you will see it does talk about the value of the equivalent value of the gold and the actual gold in terms of kilos. And if you see, there is an increase from 2020 to 21, and 21 and 22, the amount almost remains the same.
Right. So that answers your question, I think, Mr. Ghosh.
Yes.
Anything else?
No.
Right. Mrs. Bejoy, do you want to come back on that point? I will give you both again an opportunity to come back on any other questions I ask.
I don't have any question for now, Your Honor.
Right. Thank you very much. So let me just look at my notes, Mr. Bassi. Give me a moment to check that I that everything I needed to know. Were you aware of the fact, Mr. Bassi, that under the Memorandum of Understanding, I'll take you to it, I'm not sure where it is in your bundle. Under the Memorandum of Understanding, there is a side heading. Unfortunately, it's an internal page. I'll give you the internal page number, page 5, center bottom, page 5. There is a heading, JV Company Consultant. Do you see that in the MOU?
Yes, yes, Your Honor, I can see it.
And what that says is, from the date of the gold advancement, Shakti Chauhan shall provide consultancy services to the JV company on an ad hoc basis and shall be paid a consultancy fee of 10% of the JV company's net profits for each financial year that the JV company conducts the business. All right. There is evidence before me. Again, I'm not indicating any view on it, whether I will accept it or reject it, but there is evidence before me that because Snyder Prime did not introduce the full amount of gold promised, namely 200 kilograms, his fee of 10% was reduced proportionately to the shortfall in the gold that he had produced as compared with what he promised to produce. So that his 10% in the year to the year end 2018, I'll be corrected if I'm wrong, was reduced proportionately so that the company was compensating itself for his failure to introduce the gold. I only want to know if you were made aware of that fact, if it indeed is a fact.
Your Honor, I'm not aware of that fact. I have not had that discussion on that specific clause of the MOU, as our scope was to look at, compute the loss of profit on account of the shortfall and not the resultant payout or the lack of it to anyone as a result of the potential profit.
Very well. And I think my final question is this. This is really a question relating to your expertise as an accountant. You've already been asked questions about or derived from that expertise. I would just like to know this. If gold of 200 kilograms or equivalent value had been invested in the company for a period of 5 years, or indeed for any period, as working capital, where would it appear in the financial statements? I think I know the answer, but I don't want to assume any technical competence as an accountant. Where should it appear year on year in the financial statements? And you can use any of the financial statements that you have relied on to answer that question for me. In other words, if it was provided, where would it be recorded in the financial statements?
Your Honor, just please give me a second. I will pull up one of the audited financial statements and I can show you where it appears.
Show me, if you will, in the claimed loss period. Do you follow me? In the accounts for the claimed loss period.
Understood. Your Honor, if you go to the financials, audited financial statements, and I'll give you the exact page number in the trial bundle.
Please do.
it should be 365.
Yes. Just
If you
getting
look
there.
at,
I'm
yeah, if you look at the,
just getting
Sure.
there. Sorry. Yes.
if you look at the statement of financial position as at 31st December 2020, under
Yes.
equity funds, it's third from the top in that section, gold account.
Sorry, I lost the page then. I'm on page 365. I'm
Under
looking at 2020. What is the heading?
the heading is equity funds. It starts with share capital, under equity funds, then it's retained earnings, then it's gold account.
Yes, I see. So that's where I'm awfully sorry. My annotation tool deserted me.
No problem, sir.
The gold account, so the figure of 6.079420.
That's correct.
Yes, and in any other accounts that you want to draw attention to, that's two. You've started at 2020. Why
Sure.
do we not see anything in the gold account in 2019?
I think 2020 financial statements had reclassifications done, Your Honor, to the best of my understanding. If you see in our report, even when we talk about revenue, we have done and we have demonstrated the reconciliation of certain reclassifications. It's quite likely it's as a result of that.
Very well.
If we go to Exhibit 7, and let me just take you to the specific page number, just please bear with me, Your Honor. So in 2021, Your Honor, it's going to be page number 390. In the trial bundle, if you go to page 390.
I'm going there.
And if once you're there,
Well, we're into the informative period here, aren't we?
yes, but I wanted to show you the gold account, which is appearing under equity funds. It's the last item under equity funds, and you can see on the right side,
yes.
the balance that I just showed you from the 2020 audited financial statements, and you can see almost an increase of 100% in 21.
Yes, I have that. So can you take me to the years the accounts for the year end 2018 and 2019? Which pages are those on?
So 2019 is, Your Honor, starts at page 33. If I'm correct, it's page 334. Exhibit 5 as well. It's page 334.
Yes, it starts there. Which is the relevant page?
So in the statement of financial position is page 340.
I have it.
Yeah. And I can't see gold account there. Like I said, there was some reclassification. I don't remember offhand why that is the case, but I do know there has been some reclassification. And as a result, it's quite possible that the number is actually, or the amount is sitting somewhere else.
And then finally, 2019.
19 is what we just went
Sorry,
through.
2018 is there.
Yeah, in 2018, yes. Also, the company only started operations in 1st of September 2018.
Yes. it's not in dispute that 4.9 million was invested in the company, although it was in cash, it was accepted as being performance of the investment of 100 kilograms of gold. And you say it may have been somewhere else. It is definitely somewhere else because we've just been looking at it, have we not? And I'm just trying to remember which part of the accounts it is in. Can somebody help me with that, please? Let's stay with the 2019 accounts. Yes, there it is. It's in the statement of financial position at page 340. It's there shown as a current liability, convertible loan.
Yes.
Now, is that an appropriate treatment in the accounts for invested gold? Mr.
Sorry, is that a question for me?
Yeah, it is. I'm asking you, do you see, we're looking at page 340, and we have this figure representing 100 kilograms of gold. You see where it is placed in the accounts as a current liability. But it's not in dispute between the parties that represents the 100 kilograms of gold that you have been understanding to be half of the promised investment, and that is where it is found or allocated in these accounts. Is there anything wrong with it appearing in that position in the accounts?
Your Honor, I can't comment on that because I'll have to see the underlying documentation and how the auditor decided to treat that particular information and accordingly account for it in the financial statements.
Very well, but no doubt, there's no doubt it is there evidenced in the accounts as a liability of the company. Very well. Well, I have no more questions in that vein. Mr. Ghosh, do you wish to come back on that question?
Yes, Your Honor. So I'll go back to the first audited statement 2018.
It's on
Again,
that same page, or is it something else you want to show?
No, same page 332.
332, yes.
So, Mr. Basi, you just mentioned, you showed to His Lordship accounting audited statements of 2020 and 2021, and the exact name or nomenclature for the gold which has come in. So it is shown as gold. What was the heading, Mr. Basi? I just forgot.
Your Honor, can I please ask which specific financial statements are we referring to?
No, now we are referring to page 332.
332, okay.
Yeah, 332. My question is related to your affirmation a few minutes ago, saying that you showed to our Lordship that at page in the year 2021 or 2020, it is showing under the gold as equity funds under gold fund, I think. So can it be considered that at page 332, according to accounting standards, this gold loan from third party could be a part of that gold as equity?
Your Honor, I will not be able to comment on it unless I look at both transactions and the underlying documentation. I can only then comment on how and what has been included in the amounts under page 332.
So you have already mentioned that you did not have these documents except from Al Asil, that is 4.9 million.
You know, I'm not sure of the question. I'm a little confused here what the question is.
I will come back to you 1 second. I'll just open the exhibit 6 and exhibit 7, I think. Yeah, I'll open exhibit 7.
Page, please, Mr. Ghosh.
Yes, just a second.
Exhibit 7 starts at page 385.
Yeah, and the relevant page is 390.
Okay.
Under equity funds, the gold account, which you just showed, for 2 years, one is 2020, one is 2021. It increased significantly
Right.
in the year 2021.
Right.
So when you say gold account, and when we go back to page 332, I'm just trying to question you on the words, because I'm not an accounts guy, so probably you'll understand more than I do, that whether at page 332, the convertible loans at serial number 3 were gold loan from third party, which is showing in this audited statement. This gold loan could have been considered there also.
So, Your Honor, I think we are comparing two different things. What is included or in any audited financial statement under liability is a liability. What we are seeing on page 390 is essentially part of the equity and not the liability.
Well, there you have your answer, Mr. Ghosh.
Yes, just one more question. Coming to your report, paragraph 5.4, which is at 5.4.
Page, please.
Yes, page is 269.
269, 5.4.
Yes,
Your Honor, I'm just trying to find that 5.4.
your
Yes,
report.
I found it.
Yes. So in the methodology of your loss of profit computation, you have said that given that the AFS of 21 and 22 are reflective of SPM's operations with a working capital of gold 200 kg, they provide the best indication of the company's performance when operating at the agreed working capital of 200 kg of gold as per the 2018 MOU. Accordingly, I've used the figures for these years as the base figures for my calculation. So do you think that as 2018 or 2018 was the beginning of the company, basically, the very formation years, so you are using a performance number after 5 years since inception to calculate the number in the first year? Don't you think it's a gross exaggeration?
Your Honor, actually, that is not what we have done to compute the loss of profit. What we have done is we have considered the period from 1st of Jan 2021 until 31st of December 2022 actual financial results as the informative period. That is a starting point for us to look at, because we have had the benefit in hindsight of the company having operated at 200 kilos of working capital. Normally, when we compute loss of profits, you're always trying to compute a future number. In this case, we had the benefit of the company's results with 200 kilos. We started with the actual results during those years, and we then adjusted, as has been explained in my methodology, to arrive at what could have been the results if the company had 200 kilos available from day one, which is 1st September 2018, which is the until 31st December 2020, which is the actual claim period. I've also adjusted for a ramp up percentage, as has been explained in my methodology, to account for any exaggerations that may have been or that potentially could be claimed as a result of this exercise.
Thank you very much.
Thank you.
Thank you, Mr. Ghosh. Now, Mrs. Bijoy, I have no more questions. Do you wish to come back on anything that I have asked?
No, Your Honor, I do not have any re-examination questions.
Very well, thank you. Well, Mr. Bassi, it's been shorter than we anticipated, but nonetheless helpful to us all. Thank you very much for giving us the benefit of your wisdom and expertise. Your evidence is complete and you may leave us now. We have some administrative matters to deal with. Thank you for your attendance.
Thank you, Your Honor. Thank you, everyone. Thanks.
Thank you.
Right. So that is the end of all of the evidence in the case. And I've given you an indication of my preference for written closing submissions. Question is, how long are you asking for, or have you agreed on a period within which to produce them? How long do you need?
When we discussed, I mentioned Monday. So
Yes.
if coming Monday. So
Your Honor, I would like to request for at least 2 weeks because we are still waiting for the transcript to be available.
Yes.
And there are many issues that has now come in the trial that we need to carefully examine and put across a submission that would be really helpful to you in terms of deciding on the issues. Although the issues are only 3, but the sub-issues evolving from them are numerous.
Numerous indeed they are. I'm well aware of that. Mr. Ghosh, I would prefer you to take your time over this, have the benefit of the transcripts, and provide me with focused and well thought out submissions. So I'm going to say 2 weeks. What date does that take us to? Just give me 1 second.
We are on 11 today, so if we
25th.
may agree, yeah. So 25th being a Thursday, if we can push it to 26th Friday.
Yes, 26th of July, written closing submissions. Now,
Grateful, Your Honor.
I think it would be appropriate to have a page limit to those submissions. What would you suggest would be an appropriate limit? I'll go with you first, Mrs. Bejoy, on this.
I'm thinking maybe maximum of 20 pages.
Yes,
That would not be.
that sounds about right, Mr. Ghosh, does it not?
yes, 20 is fine. 20
pages, limited to 20 pages, normal font type and spacing. I don't have to say any more, do I? I have had I've had submissions with microfine print that can only be read with I'm going to show you. I actually have it. I have it from past experience. But I'll trust you. Normal font size and spacing, please. And I have a few points I wish to make about the focus of the submissions that I want you to consider. You will appreciate that the court may not accept, it may accept the case completely for one side of or the other, find the evidence on one side or the other to be completely compelling, in full, in whole, and reject it. But it may also find that the evidence and submissions that have been made on both sides are wrong in part, right in part, do not properly analyze the contractual instruments in play, that some evidence should be accepted from one side and not other parts of its evidence, and vice versa on the other side. I'm sure you understand all of that. That I may reach conclusions which are not the conclusions that either side is putting before me. That I may have an interpretation of these agreements contrary to the submissions that you are both making on them. And I've given one example of that already at the outset, and I want you to deal with this specifically in your submissions. That the share transfer agreement represents a variation and waiver of the obligations under the MOU, that it changed things. And you need to address me on the terminology, the terms used, on their interpretation, and I will reach a view based on those submissions, and it may not be the view that either of you submit to me. Do you follow that? The second point that I need to make absolutely clear upon my further consideration of the issues which were defined for trial, actually before I became the judge to whom this case was allocated. I mentioned earlier issue 1C. Somebody please turn off their microphone. This is intolerable. Somebody who's should not have their microphone on. There is a very bad echo. There's nobody else with me or near me, and I don't know whether there's anybody else near either of you, but really I'm talking only to you two and only need your responses.
Lordship, I think it's coming from your side only because I just switched off and it was still echoing.
I can also keep mine closed.
Right, turn yours off, Mr. Ghosh, as well, and let's see. Right. I'm not hearing any echo now. I don't need you to respond. So it must have been coming from one of your microphones somewhere. Anyway, we've resolved it. I will speak, and then you can turn on and come back to me. So I was addressing issue 1C. What is the effect of signing the shareholder resolution dated the 31st of December 2020, and what are the obligations of the parties therefrom? It seems to me that all the relevant evidence has been given as to what the effect, the competing evidence, as to what the effect of that resolution was, and what obligations it gave rise to. There was a suggestion of coercion, but I've heard the evidence on that, and it is limited to, came from Mr. Shakti Chauhan, where he told me that he signed that agreement because if he did not, he understood that Mr. Garg's capital would be withdrawn and that the company would be forced into liquidation. And if you would turn on your microphone, Mr. Ghosh, and tell me you're nodding in agreement with what I'm saying, but can you confirm that that is the case, that is his case on why he signed that agreement?
Yes, Your Honor. That's what he mentioned before, Your Lordship also.
And there's no more to it than that, and I will have to decide whether the agreement is binding and effective and what it means. Do you accept that?
Yes.
Very well. Mrs. Bejoy, do you likewise accept that with this definition of issue 1C, in these proceedings, I have to interpret the resolution of the 31st of December and determine whether it is a binding agreement between the parties in this litigation, and what its effect is, what its meaning and effect is, and express that in a form of declaration.
Yes, Your Honor, I'm fine with this approach.
And I saw again you were nodding, Mr. Ghosh. You also accept that, do you?
Yes, in fact, if your lordship recollects, one of my arguments, opening arguments was that, and of course, you're also right saying that company is a different entity and the shareholders are different entities. So the profits or from the dividends of the claimant number one goes to the two shareholders. One is the claimant number two and claimant number three. So obviously, I was preparing my closing submissions today in the morning.
Yes.
So,
So yeah, I understand what you're saying, but whatever its effect, the resolution is a resolution of the company, that is the resolution of the 31st of December 2020, but it also represents an agreement between the company's shareholders. What it means is for me to determine, but do you accept that it represents an agreement between the three shareholders of the company? It is actually a shareholders meeting, a resolution from a shareholders meeting, so that my decision on issue 1C will provide the parties with a ruling as to what are the obligations of the parties. Therefrom, the parties are all the parties in the litigation. You agree, Mr. Ghosh?
yes, of course.
And you, Mrs. B. Joy?
Yes, Your Honor, I'm looking at 1C in terms of, I'm just trying to understand what impact this decision will have on the other pending proceedings.
Well, this is the whole point of trying these issues first, because all that has arisen and that is the subject of dispute in CFI 019 stems from a competing view about the effect of this resolution, does it not? You're both nodding. You can have your
Yes.
microphones on. I'll put it. Do you agree, Mrs. B. Joy, with that?
Yes, I do, Your Honor. Yes.
And do you agree with that, Mr. Ghosh?
Yes, of course. I mean, those were the allegations of Snyder Prime, which 019, of course,
Yes.
I mean, it boils down to the board resolution of 2020 December.
Well, that's very helpful. So,
and Your Honor, there is also another thing. I think part of the dispute is also because of the ownership change in Snyder and the lack of disclosure.
Well, you can make submissions on that. That's
not in this current proceeding, Your Honor.
No, you can make submissions on that when we come to CFI 019 if we do. But it may be that whichever way I decide, and you will both readily accept, I have not made any decisions. This is a very difficult case and dispute. When I make my decisions one way or another, and I determine issue 1C by way of defining the obligations of the parties and declaring them, that either way should assist the parties to resolve their disputes in CFI 019. At least it may provide some assistance to them, and it will be res judicata. So as long as you are both in agreement with those observations I have made and the approach that I intend to It's definitely coming from your end, that echo. Just turn your microphones off for a minute, will you please, both?
Your
Thank
Honor, I
you.
think the echo has stopped, so I believe.
You know what it was, do you?
Yes, yes, it is. But it was not coming from my system, I think,
All
because
right.
it's
Well,
not hearing now,
you're not
and
hearing
my
it now.
microphone is on.
All right. But just let's finish this off. You're both in agreement with my approach to determining issue 1C, whether it has any beneficial or detrimental effect on the outcome of CFI 019 is not something we can consider today, but the whole point and purpose of this bifurcation or separation of issues for trial should serve a useful purpose, and I believe it will. But it will also enable you to fashion your written submissions to address how I should decide issue 1C. And I've made it clear to you now how I will be approaching that issue in the light of all the evidence before me. So yes, I will wait 2 weeks with anticipation for your submissions, and 20 pages long. Oh, the final point is this. On both sides, certainly on your side, Mrs. B. Joy, and this is not in any sense a criticism, indeed a commendation of your industry, there is a massive span of reference to English authorities, but this case falls to be decided under DIFC laws. I appreciate the recourse to English common law authorities, but it is to be decided under the contract law and the law of obligations of the DIFC. So I would very much appreciate your submissions on the sub-issues to be fashioned by reference to that law. By all means, if you then want to refer to a relevant English, Australian, New Zealand, Singapore, Hong Kong authority, Indian authority, I'm desperately sorry I did not mention the common law of India. Its wealth and depth is wonderful. So wherever assistance may come from, I will receive it gratefully, but your focus should be on the applicable law, which is the DIFC laws, which I have mentioned. So is there any further guidance I can give you?
Yes, yes, Your Honor. So, yeah, this last point of yours is very helpful. So, I mean, in skeleton arguments, as far as the defendant is concerned, there have been no precedents which have been provided so far. The reason for that is I was waiting for the evidence and everything to the trial to be completed. So, am I allowed to refer to some judgments?
Of course,
Yes.
course you may. The only stipulation I've not provided for reply submissions is that you should give notice to Mrs. B. Joy of any authorities that you intend to rely on. And having regard to the complexity of this, I will hear you both. I don't think it's necessary as to whether there should be a very short reply submission within, say, a further 3 or 4 days from the filing of the original submissions that I've provided for. This is a very complex and difficult case, and I know a lot turns on it. If you you must provide Mrs. B. Joy with any authorities you intend to rely on before she provides her written submissions, and she likewise, if she intends to rely on something new that's not already deployed in her bundle. So what do you say? Do you apply for an opportunity to make brief submissions in reply, or are you content with an early exchange? I've given you till the 26th of July. We could pick a date in the middle for an exchange of authorities that you each sought to rely on. Those are the options.
I believe if Mrs. Bijoy agrees, a reply submission would be better, because if we provide the documents or the judgments to her, say 7 days before, I mean, that might make a change her submission. So why don't we do it after the submissions are made on the 25th or 26th, and reply to each other's any new judgments which she relies on or I rely on the next week.
What do you say, Mrs. Bijoy, to that?
Your Honor, I have a humble observation that we do both simultaneously, because the way the previous pleadings, the witness statements have been flying around, I am assuming that we would then be opening up a new window where there would be numerous exchange. So I believe it would be a better approach that both of us make submissions on the same day, and that is the end of it, because we had the benefit of pleadings, evidence, disclosure, and trial.
What about the exchange of authorities 7 days before the 7 days before the 26th of July? A list of authorities that you seek to rely on in your closing submissions.
Yes, agreed.
That is fine, Your Honor.
19th.
We can exchange the authorities, and
Right.
likewise, they can also exchange their list of authorities.
Yes.
Because as I think that there will be deviations from the authorities that we have submitted along with the skeleton, because the way the trial has evolved, we may be completely disregarding the existing set of authorities that we have relied on. More so because now the focus is on the DIFC, contract law, and the law of obligations. Yes. We would still try and see if we can find some precedents, although we did try, and we will continue to do that. So well, I think
I'm very grateful you've said that, because I did look at the authorities, and a lot of them are now clearly irrelevant. So I think you'll be able to whittle down your list of authorities very considerably if your focus is on the applicable law of the DIFC. So what I'm going to order is the 26th of July is a Friday. So the Friday before is the 19th. The parties shall exchange lists of authorities on which they intend to rely in their closing submissions, to be simultaneously exchanged on 26th of July. Does that
Yes.
satisfy you both? And then you can address those authorities from the other side as you see fit in the closing submissions. Well,
if I please interfere. Sorry about this last minute clarification. I understand. I would like you to go back to the discussions that we had on issue number 1C. Yes. It is not very clear to me whether we have to make submissions on the aspect of coercion or limited to the extent of interpreting and implementation of 1C on the December 31st resolution, because my difficulty is initially we had this discussion in the opening, and we were proceeding under the impression that the aspect of coercion would not be taken up in the trial. So we did not raise any questions with respect to the coercion. And even I think by looking at the witness evidence of Mr. Shakti, there is only a passive reference on the coercion. They also do not have a strong case of coercion.
Well, the evidence was given, and I cannot recall if you cross-examined to it or not. And it is confined to a commercial situation, which he outlined. And I don't see any reason why the case on coercion did not go beyond that at all. So I don't see any reason why you cannot address that in your closing submissions on the basis of all of the evidence that was given by Mr. Garg gave extensive evidence about why and how this agreement came about. It was his case that the defendant, Mr. Shakti, suggested it. That was disputed. That was an issue. You were in a position to deal with that. So it seems to me that I'm equipped to determine whether this is an effective agreement, not vitiated, or whether or not vitiated by the very limited suggestion that he felt forced into signing it because if he didn't, the capital would be withdrawn and the company would go into liquidation. Do you say you're not able to deal with that suggestion?
Yes, Your Honor. So one thing that I would like to distinguish is we are talking about an STA and we are also talking about a board resolution that was passed subsequent to the STA. So if we look at the date of the STA, that's on the 20th of February 2020. And it was for the signing of the STA that the pressure, whatever evidence the witness has said about Mr. Garg pulling out the 100 kg of gold. And the matter that we are going to be discussing under 1C is not the STA, but the subsequent board resolution, which was implemented from the 31st of December 2020. So the matters are two different here. So I am thinking, how would the coercion issue would address the effectiveness of an STA? Are we looking at from that point of view, or are we looking at in terms of the effect of coercion on the implementation of the 31st December 2020 resolution?
Well, I'll have to look at the evidence, but I understood Mr. Shakti's evidence to be on the basis that he signed the resolution because he believed that if he did not sign.
Of course, Your Honor, I would definitely be grateful for that clarification because if you are trying to interpret the 31st December 2020 resolution in terms of Mr. Garg's stand that he's going to withdraw the gold, that wouldn't be applicable because the STA has been implemented from 2020 and the parties have transferred the shares. Company has been moving on. So I believe that would then lead to a different conclusion altogether.
Well, these are your arguments, and that is, and you're able to make them, and I will receive them and hear them. But it seems to me I'm in a position to determine whether the resolution has binding effect on all the evidence that I've heard in this case. Do you agree with that?
Yes, Your Honor. We will make our submissions.
Right. You make your submissions, and you can address, as Mr. Ghosh can address, whether he maintains his case that he acted under any kind of coercion. I will consider it, and I will consider your submissions to the contrary. But you both agree that I'm in a position to determine whether the resolution is an effective and binding agreement on the evidence that I've heard. Do you both agree with that? You're both nodding, but
yes.
Yes, Your Honor. To the limited extent, I would say, because I think we initially started off on the interpretation and implementation of the board resolution of 2020.
Well, that is effectively it, isn't it? That's what I'm doing.
Yes, it is. Yes, it is.
And whilst I might have said that I'm not dealing with coercion as alleged in CFI 019, that's not what is being alleged here. And I've heard evidence on it on both sides. So I'm able to determine whether that agreement in the resolution, what it means, and whether it has binding effect. And that is what I propose to do, unless you wish to make any further submissions and demonstrate why I should not do that.
It is clear, Your Honor. So I agree with your approach. Yes, to the extent of ruling on the binding nature and the interpretation, yes, we will be making submissions on that.
Very well. We're all ad idem then, and I shall look forward to your submissions and proceed accordingly. I warn you, it may take me a little while to digest all of the arguments I am anticipating on the basis of what I've heard and seen over the last, well, we've done it in 5 days, haven't we, in total? So there we go.
Yes.
May I say something, Your Honor?
Yes, Mr. Ghosh.
Yes. I mean, before leaving, this is on a personal note. I mean, I need to apologize also, and I need to clarify also something that when the permission to extend the trial was given, and when the defendant wanted to produce some documents, we produced some documents, which was, of course, as your lordship correctly viewed, that it was in excess of what was actually decided during the trial in the month of May. Initially, there was an email exchange of objections from the claimant side, and the defendant also replied an email, and I understood from an email from the registry that your lordship insisted that the counsel should reply. So the counsel also, that is myself, I replied on email the objection, trying to convince your lordship about the correctness of the additional documents. And then I received an email that it should be put in the form of a witness statement. So that was where I had put in that witness statement, though I'm fully aware that as a counsel, I should not put in a witness statement. And that is what I wanted to mention, that it was not something which I just did it because I wanted to. I mean, it was only in the directions when I received from an immediate once the objections and the reply from my side was given in the form of an email. Within 10 minutes, there was an email from the registry asking me to put it in the form of a witness statement.
I understand that, but what concerned me, and I accept your explanation and apology without reservation, Mr. Ghosh. You should not trouble any more about it. I had to deliver the judgment that I delivered because, for the reasons which are contained in it, it is something unheard of. If it has arisen as a result of a misunderstanding, I accept that wholly and completely. And your reputation is entirely restored. Do not trouble about that a moment longer.
Thank you, Lord.
What troubled me and what was unacceptable where a party is represented by a lawyer was I received submissions in an email written by Phoebe Tuka. That was wrong. And that is what I directed should not have been done. And that was what led to the direction I gave, which was that counsel should make the submissions, not a party directly. Where counsel represents a party, the party is represented and counsel makes submissions on behalf of the party. You represent the second defendant. And
Yes.
that was what was quite improper for Ms. Tuka to, as it were, to assume your role. So there it is. It is done. It is sorted. Everybody knows what the proper procedure going forward is. And perhaps most important of all, it has absolutely no bearing whatsoever on the decisions I have to make on the evidence in this case I have now heard. And nobody should think for a moment otherwise. Is that clear and accepted?
Thank you.
Yes, Your Honor.
Well, thank you
Your
both.
Just one more last
Something
thing.
else.
Yes, we did discuss about this in the beginning of yesterday's trial. However, I would like to bring up the aspect of cost. We have submitted the statement of cost, and there has been a response that is submitted by the defendant. So we are looking for your guidance on how do we take this forward, Your Honor.
Right. Well, I have ordered costs on various occasions be paid in any event by the defendants. I don't know. I have not seen any cost submissions, but I presume that what you've tried to do is to isolate the costs that have been thrown away by the various events where I've ordered the defendants to pay the costs and quantified those costs. You told me there had been a response which was along the lines that the costs claimed were unreasonable in extent. Is that a fair summary of what you told me?
Yes, Your Honor.
I don't know whether you've replied to that or not, but you're seeking a decision because you want an order for costs effective now. Is that right?
Yes, Your Honor.
Well, the problem is, first of all, in terms of the efficiency of use of judicial time, if you were to succeed in these issues, the trial of these issues, you will get all of your costs subject to my taxation of them, my judgment on whether they're reasonable or not. And if you lose, then I will have to assess the costs that I've ordered should be paid in any event to you. So do you see that it would be a significant waste of judicial time? The echo is there again, and it is definitely not on my side. You stopped it before, so stop it again somehow. So it's a gross waste of judicial time, bearing in mind that we are at the end of the trial. I'm going to receive your submissions in 2 weeks' time. I'm then going to determine liability, in effect. I'll put it simply, the issues. I'm going to determine these issues. And it may obviate the need for a separate excursion into a determination of costs. And I don't believe that for the sake of a few weeks, it is an optimal use of judicial time for me to be making a decision on that at this stage. So I'm going to defer it to be dealt with in the ordinary way after the judgment in this case, when I will receive your submissions on costs when the judgment is out. So that is my decision. You've done your best, Mrs. B. George, for your clients, but that is my ruling.
In fact, Lordship, in all these three matters, I mean, so far the costs have been in favor of my client, but none of them have been paid so far. And it's still pending confirmation from the registry. So
All right.
it does take time.
I'll leave you to talk about
Yes.
that and deal with that as you see fit in due course. But for me, my focus is on reviewing all the evidence I've heard, my notes
Yes.
and everything, waiting for your submissions, and then proceeding to make my decisions.
Thank you.
But
Thank you.
I'm going to let you go now and sign off, and thank you for your assistance and wish you a good evening in Dubai or
Thank
India.
you.
Thank you.
Take care.
Your Honor.
Dubai. We are both in Dubai, I think.
You're both in Dubai.
Yeah. Thank you.
Take care. It's getting hotter. I know it's getting
Yes.
hotter.
Yes, it is very hot these days. Thank you very much, Your Honor.
My best departure greeting then is keep cool.
Yes.
Thank you.
Thank you.